Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Cerenade e-immigration. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And while I recently had the opportunity to talk to the folks at Cerenade about their case management system, e-immigration, they've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Cerenade. Also, check out their blog at cerenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. What to possibly talk about this week? Seems like nothing ever happens in immigration news anymore. Oh, for that to be true. In addition to the fact that it is a due process nightmare, my hearts are with those individuals apparently sent to a Salvadoran gulag who have absolutely nothing to do with that Venezuelan gang. One had an autism support tattoo, another was a gay barber, and the list seems to be growing. What a horrifying situation, if true, which honestly, I'm pretty sure it is. Preaching to the choir if you're spending your time listening to this podcast, but man, if they can send someone to a Salvadoran prison without giving them any opportunity to even argue otherwise, what's to say that they can't allege, using the Alien Enemies Act, that I'm not a citizen, that I am a terrorist, and then send me to God knows where? Nothing. Nothing really stops it, except the lawyers both within and without the US government. It's time for the bar to stand up, and despite some scary initial concessions from some of the big firms, it seems that it's beginning. I've never been more proud to be a lawyer. On that vibe, I've included a link to Just Security, documenting all the lawsuits against the Trump administration so far, including, of course, our TPS lawsuit in the Eastern District of New York. There are so many. The list is a testament to brave lawyering everywhere. My thoughts are also with the attorneys and staff from the entity Kind and similar organizations who are now flooding my LinkedIn feed with open to work messages due to the loss of federal funding from those organizations. What important entities, what a tragedy to lose so many good people, and how terrible to now make all those non-citizen children represent themselves in court. I don't think that's what the majority of Americans would want if they knew about it. Finally, a shout out to our future immigration colleagues currently with UIR, the judicial law clerks, and the attorney advisors. Whether you end up continuing on with the government after your term ends, or joining the private bar or nonprofit sector, you are our colleagues in this weird world we call immigration law. I've recently come to learn that the Trump administration has taken the unprecedented step to not promote JLCs to attorney advisors, or at least not to pay them at the attorney advisor level, even though they've passed the bar, and possibly in violation of the agreements they signed up for. A bit unclear there, but it looks like they're not getting the money, at least yet. Like so much in immigration and the federal government right now, it seems that cruelty might be the point. Hang in there, attorney advisors. Learn as much as you can and then use it in the best way you see fit. Like, for example, someday litigating cases just like these 3. Kicking it off with Delligatti v. United States, published by the U.S. Supreme Court on March 21st, 2025. Case from late last week, actually, and it's about crimes of violence in the sentence enhancement context. Justice Thomas issued the opinion for the court, with Justice Gorsuch joined by Justice Jackson dissenting. Fascinating facts, actually, and good to remember that U.S. citizens often do worse things than the non-citizens permanently exiled and discussed on the podcast so often. Mr. Delligatti is, quote, an associate of the Genovese crime family, one of the New York Mafia's so-called 5 families. In 2014, a local gas station owner hired Mr. Delligatti to kill Joseph Bonelli, a neighborhood bully and suspected police informant, end quote. Mr. Delligatti organized a bunch of mafia dudes to do it, and they even drove by his house but called it off when they saw that there were too many witnesses there. When they went back the next day to commit the crime, the murder, they were arrested. Lots of crimes were charged here, but one was using or carrying a firearm in furtherance of a crime of violence. The alleged crime of violence being New York attempted second-degree murder. Is it one? And it's nearly the identical crime of violence definition for immigration purposes, so highly relevant to us small folks, especially because it's the Supreme Court talking. It is a crime of violence, said the Supreme Court. Now, there is no question that an attempted crime of violence is a crime of violence. It's right there in the statute, the definition of a crime of violence. But crimes of violence, of course, require the use, threatened use, or attempted use of physical force, also known as violent force in some contexts, and New York's second-degree murder, quote, can be committed by an act or omission, with the latter defined as a failure to perform a legally imposed duty, end quote. So literally no attempted or threatened use of force at all. An intentional omission of force, argued Mr. Delligatti. Because remember, the categorical approach doesn't care what the defendant or non-citizen actually did, it cares only about the least culpable conduct. All courts, including the Supreme Court, rejected Mr. Delligatti's omission argument. Because, explained the Supreme Court, its Castleman decision from a few years back defines the force element required of a crime of violence as encompassing the, quote, knowing or intentional causation of bodily injury, end quote. Even if, as discussed in Castleman, the act required is mere non-forceful poisoning, for example. Doing so through omission similarly cuts it. It doesn't have to be a, quote, affirmative act, end quote, explained the Supreme Court. To the court, Castleman therefore means it is, quote, impossible to cause bodily injury without applying force, end quote. Seems to me then that the Supreme Court is condoning a trend discussed by the circuits of late and discussed on the pod. Sometimes putting the crime of violence analytical focus on the risk of harm or the harm caused and then working backwards to imply necessarily that sufficient force must have been used. Mens rea, or mental state, is really still exceptionally important post-Borden. Reckless use of force shouldn't cut it, even if bodily injury is caused. That's what the Supreme Court held in Borden a couple of terms ago. But when the actus reus requires knowing or intentional conduct, or now omissions, and the statute requires a bodily harm showing, seems like you've got a Supreme Court-sanctioned crime of violence. To the Supreme Court, this also follows from the crime of violence definition's use of, well, the term use. Quote, a person uses force in that sense when he makes force his instrument, whether directly or indirectly, end quote. You still need to, quote, knowingly cause physical harm, end quote. But if that's the minimum conduct required of the statute, it seems that a crime of violence finding will be hard to avoid. Flat out to the majority, quote, any force that actually causes injury or death, end quote, is violent force, as defined by the crime of violence statutes. So if the statute requires a sufficient mens rea, you probably have a match. And that follows largely both from Castleman and the Supreme Court's Stokeling decision from a few years ago. Bad facts, of course, make bad law for non-citizens often. For, turning to the New York attempted murder statute at issue, quote, "It should go without saying, intentionally causing death counts as deliberately causing injury," end quote. As to Mr. Delligatti's specific omission argument, the court rejected it specifically because it still sees death or harm by omission as a sufficient cause attributable to the omitting actor. For example, quote, "A mother who purposefully kills her child by declining to intervene when the child finds bleach and starts drinking it makes use of the bleach's poisonous properties to accomplish her unlawful end," end quote. Okay. But hypothetically, hear me out, Justice Thomas, just hypothetically, what if a U.S. president surrounded by unwitting scientists tells millions of people freaking out in the midst of a horrific pandemic that they should drink bleach to protect themselves, knowing that it won't protect them, and then someone dies? Has that hypothetical president committed a crime of violence on a mass scale? Just a mental exercise, people, just a mental exercise. Anyway, returning to Mr. Delligatti. To the court, including murder as a crime of violence also furthers the, quote, "ordinary meaning," end quote, of the crime of violence definition. It's clearly one of the main things that Congress was thinking about when it legislated the crime of violence definition at issue here, that is, murder. Heads up to immigration people, the Supreme Court flat out says that Congress believed, quote, "knowingly causing non-lethal injury to one's child by neglect," end quote, should also qualify. While there is a knowing mens rea required in that sentence, the states, in my experience, have quite a few expansive child abuse statutes. Be wary with your clients then, and what they plead to, given the crime of violence and crime of domestic violence removability provisions. Going forward, a crime that permits harm to a child by omission with a knowing or intentional mens rea, or, of course, a crime of child abuse, abandonment, or neglect. Majority here rejects a few more positions and tangles with the dissent and affirmed Mr. Delligatti's conviction. Justice Gorsuch believes that the majority whizzed past the crime of violence text and that in any event, the rule of lenity should apply. Don't forget lenity! Only 2 justices, though. And a heads up. If you're making a Borden-type mens rea argument to avoid a crime of violence finding, peek the fairly confusing footnote 5 from this decision to make sure you're making the right argument. It seems that Justice Thomas, who apparently provided the decisive vote in Borden, isn't quite sure how far Borden's holding really goes. Check it out, make sure you have the right argument. And that is Delligatti, the United States. Next up is Ayala Chapa v. Bondi, published by the Fifth Circuit on March 24th, 2025. This case comes to us, although really the Fifth Circuit, on remand from the Supreme Court. The original Fifth Circuit decision was discussed on episode 149. This case is about cancellation of removal, but really it's about temporary appellate IJs, also known as temporary BIA members. Mr. Ayala Chapa is from Mexico and has been here since his youth. Unsure if he obtained lawful permanent resident status, but I suspect he did. His criminal history began in his youth and ultimately made him removable for a drug offense. An immigration judge and then the BIA denied relief, and the BIA denied a motion to reconsider. Of particular importance, the BIA decision in this case, or decisions, were issued by a single temporary appellate IJ, who had served as a temporary IJ longer than the normal 6-month appointment permitted by regulation. At least the old regulations which governed this decision. The Fifth Circuit originally refused to hear any of this, in large part, it seems, based on its unique rule about filing motions to reconsider with the BIA post-removal order in order to administratively exhaust arguments. Supreme Court, however, got rid of that weird rule in Santos Zacaria, and now here we are. At least in part. The first argument before the Fifth Circuit, and really the only one it decided to address in this decision, was that the BIA, quote, acted ultra vires in ordering Ms. Ayala Chapa's removal because a temporary board member issued the order after her temporary term expired, end quote. To the Fifth Circuit, though, that appears to be an argument based on the BIA's own regulations. And in addition to every circuit to have addressed this argument rejecting it, the Fifth Circuit is, quote, unaware of a case holding that an agency acts ultra vires when it strays beyond its regulations, end quote. Ultra vires claims are more about an agency doing something beyond or different from what Congress's statute requires. But going beyond or different from the agency's own regulation? Maybe that's a due process argument, explains the Fifth Circuit, but it's not an ultra vires claim. It is, after all, quote, a long-settled principle of administrative law that agencies must follow their own regulations, end quote, and fair enough. But a due process claim, of course, requires a prejudice showing in addition, at least in the Fifth Circuit, and at least with a regulation violation of this nature. So if it's not ultra vires, and if you don't have a due process argument, you don't really have a claim, explained the court. The Fifth Circuit then anyway went on to say what the other circuits have said. Reappointment of these temporary BIA members is occurring by and through the Attorney General, rather than EOIR's director, which is proper under INA Section 103G1. Admittingly, the statutory argument in support of permitting this gets weird, but no circuit seems to be biting on the arguments, and I believe there's a 2024 regulation now addressing the issue that probably forecloses these arguments going forward. And that's pretty much it. The Fifth Circuit didn't believe that any of its other prior decisions in this case were remanded to it by the Supreme Court. So, having rejected the temporary appellate IJ argument, the Fifth Circuit ruled against Mr. Ayala Chapa. Again. And that is Ayala Chapa v. Bondi. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Elevate your advocacy and storytelling skills at the annual Immigration Court Trial College in Kansas City. Get ready for a transformative experience at the annual Immigration Court Trial Advocacy College, now hosted by the Pen and Sword, formerly the clinic at Sharma Crawford Attorneys at Law. That's friends of the pod and friends of the Kevin, Rekha and Michael Sharma Crawford, excellent immigration attorneys. The college convenes from April 24th to 26th and will focus on detentions, bonds, and release for 3 action-packed days of hands-on practical training and expert insights. This is not your average Talking Heads program. This is real cases, real witnesses, and real courtrooms designed to give you a real edge in your immigration practice. Put another way, this isn't just another training. It's an opportunity to transform your practice and fight for justice in a way that matters. Sharpen your skills, amplify your voice, defend immigrant rights like never before. Don't miss out, because space is limited. Check out all of the links to Rekha and Michael Sharma Crawford, their firm, and the Pen and Sword in the show notes. And if you want to get a bit of a discount for the Trial Advocacy College, click on the link in the show notes or use promo code IMREVIEW2025, that's IMMREVIEW2025. Keep up and join the good fight. Concluding with Yocom et al. v. USCIS et al. published in the Southern District of California on March 21st, 2025. It's a district court decision from my local district sent to me by my local friend. This case is about discovery, and I decided we'd do it given that it's a short week. USCIS and the US government generally never, ever want to engage in discovery in immigration matters, particularly in cases brought under the Administrative Procedures Act. But we want discovery, right? We have cases to win. Here, the plaintiffs want some discovery. They want evidence from the US government. They want court-ordered depositions of Mr. Yocom's current spouse's former spouse and of a USCIS officer. Why, you ask? Because USCIS denied an I-130 petition filed by Mr. Yocom for his current husband. This is an APA and constitutional lawsuit brought to challenge that action, initially dismissed by the district court but sent back to it by the Ninth Circuit to permit amendment of the complaint. If, that is, Mr. Yocom could plausibly allege, quote, coercive behavior, end quote, by USCIS against his current spouse's former spouse. It's complicated. Must be, right? Or we wouldn't be fighting it out in district court. The spouse, Mr. Duck, married a woman while in student status in 2011. He would later claim that he's gay, and that he did so out of family pressure. Seems like it's not disputed here that he is gay, and the current petitioner is his U.S. citizen husband. But 14 years ago, Mr. Duck married a woman, and she eventually filed an I-130 petition for him in an effort to get him a green card. At the interview, though, the wife withdrew the petition after the USCIS officer suggested that Mr. Duck was gay, which I guess he is. Doesn't necessarily mean that first marriage was fraudulent, though. I mean, people get married for many reasons. I believe the Freddie Mercury movie, and of course, his life, had a similar subplot, if I recall. Here, though, the U.S. citizen wife signed a sworn statement that read, quote, "We are friends. We have never been intimate together. We have never lived together. We got married only to help him get a green card. I received no money yet, but he is going to take me out later and pay. Nobody else knows about this," end quote. Pretty bad piece of evidence. And DHS initiated removal proceedings against Mr. Duck, which were later administratively closed, apparently, after Mr. Duck got married to his current husband. Once Mr. Yocom filed that I-130 petition, USCIS, of course, denied it, making an INA Section 204C finding. That finding destroys Mr. Duck's ability to get a green card in the United States, because it means that he can never get an I-130 petition again approved for him based on this finding that he had previously engaged in marriage fraud. Them's the rules, if true. Mr. Yocom and Mr. Duck sued, as is their right. The Supreme Court hasn't taken that away yet, and they wanted to do what all litigants do in federal court, take depositions to try to prove their case. Seems that the ex-wife might not want to comply, and the USCIS officer definitely doesn't want to comply. But they must, said the magistrate judge. Because you see, while APA claims are generally limited to the record that was before the agency, and so discovery is often not permitted in federal court, constitutional claims are not so limited. That is one reason it is so important to also bring constitutional claims alongside your APA claims in your district court lawsuits. The plaintiffs here want to obtain evidence to try to prove their constitutional claim, permitted and indeed expected in virtually all other areas of litigation. The 2019 Ninth Circuit decision Sierra v. Trump is largely on the side of discovery in situations like this, so long as, it would seem, the constitutional claim isn't simply an APA claim wrapped up in, well, constitutional clothing. Some district court precedent describes the standard less like a garment metaphor and more like this. Do the claims, quote, fundamentally overlap, end quote? If so, no discovery, because it's pretty much just an APA claim. Not the case here, argue the plaintiffs, relying on the 2013 Ninth Circuit decision Ching v. Mayorkas. That is DHS Secretary Mayorkas before he was DHS Secretary and when he was USCIS Director. A due process claim like this, explained the Ninth Circuit there, quote, challenges the USCIS and BIA reliance on unreliable evidence without sufficient procedural safeguards. whereas the APA claim challenges those agencies' failure to adhere to procedural requirements, applying an incorrect legal standard and overlooking evidence and arguments, end quote. Those are two distinct things. That's Ching v. Mayorkas, the former being a constitutional claim and thus getting discovery. Is this case like that? It is. Said again, the magistrate judge on behalf of the district court. Particularly as the discovery requested here is limited in scope to those two depositions. Indeed, quote, in Ching, the Ninth Circuit recognized that the denial of an I-130 petition implicates due process rights because the decision is non-discretionary once the statutory requirements are met, and that due process requires a hearing where the petitioner can confront witnesses who may or may not have provided false testimony, end quote. So, pretty on point, that is Ching v. Mayorkas. Particularly as, again, the claim is that the ex-wife's statements were coerced. This, even though Mr. Duck was apparently in the room with his ex-wife way back when it all went down. And here we go. The Department of Justice argued before the magistrate judge that after United States v. Munoz, the Supreme Court decision from last term on the doctrine of consular non-reviewability, quote, plaintiffs have only a limited interest at stake, as plaintiffs have no protected interest in residing in the United States, end quote. That is, a husband with his spouse. Ipso facto, argued DOJ, they shouldn't be permitted to get any discovery, or even make their constitutional claim. DOJ's just riffing here based on scary precedent, guys. Don't be too harsh. The argument was rejected by the district court, or at least it was avoided, given that Munoz was not about non-discretionary I-130s at all, but was instead about the morass of consular processing with waivers. Indeed, Mr. Munoz was the beneficiary of an approved I-130, and now might be separated from his wife forever. But it involved the consulates and the discretionary act of letting in someone who may, or may not, be affiliated with MS-13. Not so here. This is the non-discretionary approval of an I-130 if the factors are met. It all means that the plaintiffs here are getting their depos. Can't wait to learn what they find. Held the magistrate judge in the Southern District of California. Meaning, congratulations San Diego litigator extraordinaire Josh Altman. Friend of the pod and friend of the Kevin. Indeed, Josh has been an immigration review nerd pretty much since the beginning, getting in touch with me way back when my wife and I were doing episodes while traveling across the country nearly 5 years ago. He's also a fellow EOIR alum. See all the good we can do when given the chance to succeed through your honors program, Attorney General Bondi? Not to mention, of course, all the talented former attorney advisors now serving within DHS, DOJ, and the many other U.S. government acronyms. The honors program is so important. Bring it back. Nice work, Josh. Good luck on discovery. And that is Yocom et al., the USCIS et al. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook @Immigration Review, or send us a tweet @ImReview. That's IMM Review. And we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.